From the News Channel 5 Network, this is Morning Line with Nick Barris.
Good morning, everyone. Nick Barris here. Thanks for joining us on Morning Line this Monday. I hope you had a very pleasant weekend. Kicking things off today, we're going to open up the phone lines. We're going to talk about some legal issues, some high-profile cases. Many of you will recall the high-profile case just before Christmas 2 years ago outside the Dogwood Bar in Midtown, Nashville, over near Vanderbilt. There was a triple stabbing where 2 people died. Michael Mosley was arrested and charged, and he claims he acted in self-defense. The prosecutor's office says that they are seeking 2 counts of first-degree murder, 1 count of attempted first-degree murder. The trial was expected to begin today. It's been postponed. A lot of people waiting for this case to move forward. A lot of the families of the deceased and the like, of course, Mosley's family as well. Postponed now till January 20th. For a variety of reasons. I have a special report that's airing on this tonight at 6 o'clock, but I've corresponded with Mosley. He's written me letters here before, talking about self-defense and some other things. We're going to talk about why these delays come about and talk about an offer he's made with regard to a plea deal and, just get some take on it from our legal analyst here at News Channel 5. We're going to talk about some other cases as well, but that, of course, would be News Channel 5 legal analyst Nick Leonardo, who's sitting right over there, and every time you come back, it's just like putting on a glove.
Well, it's like we never left, right?
Yeah, you know what? I mean, we haven't done a gavel-to-gavel in a while, but I'm sure there will be others on the horizon. In fact, as a matter of fact, the next gavel-to-gavel that we are expected that we'll probably do will be the Waffle House shooting with Travis Ranking, which is scheduled for February
That's right.
of next year, which is likely one. Again, a lot of people wonder, and we'll talk more about Mosley in a moment, but the delays, Nick. And I know that one big reason for delays across the board was COVID. And you've talked a lot about that in the past. Have things kind of gotten back to normal to some degree in terms of getting cases? And why, beyond COVID, sometimes are some of these cases years in the making?
Okay, well, that's a great question. I mean, so COVID did set us back, as it did all across America. And so typically on a Monday, like today, you would have all 6 of our criminal courts would be having jurors brought in for potential jury trials. And so you may have 300 people or a couple hundred at least in the jury assembly room, and they're brought up to the courtrooms and questioned and the like. And now because of COVID, we're not putting that many people in the jury assembly room. And so, but now, for the longest time, we did not have jury trials. And so Supreme Court has allowed us to begin having jury trials again. And so the system is very behind. And of course, there's always delays. But now we've lost about 18 months, 14 months of people that are in jail, presumed innocent, that can't afford to make bond, awaiting their day in court to go to trial, as well as the victims' families who are waiting for some sort of closure from that system as well.
Yeah, I mean, they wait, and wait. Just aside from COVID, setting that over here, when there are delays, a lot of times it's the defense themselves that will say we need more time, right?
Sure. I mean, it can be the defense or the prosecution. I mean, we've seen that in several cases. We saw that in Joe Clyde Daniels. I think the prosecution had asked for some continuances. And here, I think you had reported that there may be some issues with Mr. Mosley's defense counsel, right, Justin Johnson. And then when I looked him up on the Court of Criminal, the Circuit Court Clerk website or Criminal Court Clerk website here, it looks as though they have Mike Engel down. You remember Mike Engel?
Sure.
So
former
maybe
public defender who was involved. He represented a very high-profile case years ago, Paul Reed.
That's right. That's right.
But yeah, you're right. Good for you. Nick always doing his homework. Justin Johnson, well-known local attorney, represented him originally. He's off it. And Mike Engel. Now here's what's
Is he
interesting.
officially off it? Is that
yes.
Okay.
Yeah, it's now Mike Engel. Or I understand, again, having corresponded with Mosley a bit, that he says he wants another attorney. So I'm wondering if, as you approach a trial date, if the defendant out of the blue kind of says, I'm not getting along with my attorney, I want to have this changed, the judge can accept it, not accept it. He can ask the attorney himself, is this a problem? But I mean, that could also seem to me like just a delay tactic. Oh, I don't like my attorney, I want another one. You can't just do that willy-nilly, can you?
No, you can't do it willy-nilly. I mean, typically, once you, in a criminal case, especially here in Davidson County, once you go into criminal court, in this case, Judge Dalton's court, and you arraign someone and you say that you're going to be their attorney, you can't get off of the case because you haven't been paid. And so once you step into that role, it's got to be a really good reason for you to be removed from a case. And there are times when defense counsel and their client just don't get along or don't see eye to eye, and it's very possible that Mr. Mosley was brought in a courtroom and said he wanted Mr. Johnson fired. He doesn't want to have
I don't think that was the case. I think Johnson stepped away from it for whatever reason. It was very early on. But with Engel, my understanding from Mosley is that he doesn't want Engel as his attorney anymore. I don't know I haven't been able to get in touch with Engel to see his side of it. I've tried reaching him, but my understanding was that the judge, at least at one point, has said, no, we're moving forward with this. So if the defense attorney is not getting along with his client, is that grounds for appeal later if they can't meet eye to eye and work together? How does that work?
Well, certainly. That could be grounds for appeal. That can be what's part of the three-tier appellate process. One of those is post-conviction, where you go and argue that you had ineffective assistance of counsel, but that's well on down the road. We all know that Mike Engel's a top-notch lawyer. Mike Engel has done this, gosh, I don't know, maybe
he's been
close
around
to 40
a long
years.
time as a defense attorney.
That's right. So he's a great lawyer, but a lot of times when you're the judge, you have to try to differentiate between, is there a real conflict present here, or is this individual just not liking the messenger, okay? And maybe that message is, he's willing to plead guilty to something like manslaughter, and the state says, absolutely not. We're not going to offer you manslaughter. We're moving forward. If you want to plead guilty to first-degree murder, that's all the state's offering. Well, that's not your lawyer's fault, okay? That's the state of Tennessee, and that's the best offer that they have, which is essentially no offer, at this particular time. And so, Judge Dalton has to determine, is this just he doesn't like the message, or is there a real conflict here? And that's what the trial judge has to determine, if they're just basically shopping messengers, or if something more substantial is present.
And that may be one reason why there was a delay and it's not happening today, but you just hit it on the head. That's basically it. In the letter he sent me a couple of weeks ago, Michael Mosley said that he reached out and offered to plead guilty to voluntary manslaughter. As far as I know, and I talked to General Glenn Funk, district attorney, he's not the one specifically prosecuting this. I think Jan Norman is, along with one other assistant DA, but he said, no, that's not even an option. Right now they've charged him with first-degree murder, 2 counts, and 1 count of attempted first-degree murder. So I guess that's no surprise. But keep in mind, if Mosley is claiming self-defense and this goes to trial, it's entirely possible that the jury could see the video and decide it was self-defense and he could be acquitted, right? He
absolutely could, but when it comes to self-defense, what the jury's going to have to determine, and we're seeing it in the Rittenhouse case, and that is, did this person have a reasonable fear for their life, okay? And that reasonable fear is something that, it's hard to tell without the defendant taking the stand, but in this particular case, I believe Mr. Mosley has prior convictions, and I think there's a prior conviction involving a stabbing, okay? So that's going to be very difficult for him to take the stand to talk about how he feared for his life, and this was self-defense, without some of those other prior convictions coming in.
But you've always told me it's hard to bring up past bad actions. Are you saying for him, how will the prosecution be able to get that in if his defense brings up, oh, well, he's not someone who would stab someone, then that opens the door? Is that how that would work?
Yeah, so there you go. You're exactly right. We've got some rules of evidence that deal with when a conviction could be used against the criminally accused, and it's got to meet some criteria. But typically, if he was testifying, let's say he got up there and said, Mr. Mosley says, I'm not a violent person. I would never do something like this. I've never hurt anyone in my life. Well, then obviously there's an opportunity for them to impeach his credibility by using that. But I'm sure that there will be a jury out hearing, if they haven't already had that pre-trial, to determine the admissibility of these prior convictions, because he was on bond, I believe, at the time these alleged offenses were committed.
If there are priors or not, the main piece of evidence in this is something we haven't seen. There's been some video snippets that were made public from inside the bar initially early on. But the main chunk of it is video from outside. I'm told from Justin Johnson, who had seen it, who was the prior defense attorney, it's about 60 seconds, maybe a little over a minute, from right outside the Dogwood Bar, and it shows the stabbing, or it shows what happens in that moment. And that isn't it alone, but I guess shouldn't the jurors be able to see this and determine for themselves whether or not, looking at this, it looks like this guy is being threatened and protecting himself, or he's lashing out unreasonably.
Sure, and that's something that the defense is fortunate to some degree that's out there, because maybe if they play that video, like I said, we haven't seen it, we don't know what it shows.
But they're going to play that in court, I'm sure. Yeah, right.
And if it is clearly he's acting in self-defense, then he doesn't have to take the stand and subject himself to the collateral damage that comes a lot of times from a defendant testifying. But depending on the angles and exactly what it shows, it may still be a little bit of a hole there as to whether or not this was self-defense.
It's going to be really interesting, because talking to Justin Johnson, I haven't seen it, and I've asked him at length, Justin, now come on, he's charged with 2 counts of murder here. I mean, are you sure? And he goes, Nick, as I look at this, a very strong case can be made based on this evidence, video evidence, that it's self-defense. Jan Norman and the DA's office has seen it as well, and they're saying there's no justification for the way he acted. So they're both looking at this video and taking away a different take, which makes me think, all right, how's this going to play out with the jury? I mean, I don't think Justin's lying to me. I'm pretty sure, I haven't talked to Jan about it, but clearly she has said in court there's no justification. So she's seen the video and she takes something away from it different than Justin Johnson did.
Well, and it's important that you point out that premeditation can be formed in an instance. Okay, so it doesn't have to be something you plan for weeks. Okay, just long enough to form the intent, to kill, would be enough. But it's also important to point out equally that the jury will be instructed on all the lesser included offenses. And so if manslaughter is a killing in the heat of passion, and so if they could show that there was some sort of fight going on and this happened accidentally or whatever, then there's a good chance that they may be arguing that as a closing argument by the defense in this particular case.
Lesser included. Right. Listen, we'll take a break, and you mentioned the Rittenhouse case, and I'm curious too. It's fascinating to see that he took the stand. I want your take on that. A lot of people were surprised that he took the stand in his own defense in the case there out of Wisconsin, and broke down at one point, and how that plays with the jury, and whether or not that's something that Mosley would consider himself. We'll talk about that. We're also going to talk a little bit later as well about where we go and where things stand with regard to the defense and how it's going to play out in the Waffle House shooting case. As we're just a few months away from that going to trial in February. Some high-profile cases coming down the pike. If you have some questions about any of these, or if you just want to sit back and listen, that's fine. But you see the number on the screen, 737-7587. That's our legal analyst. He'll be answering the questions. We'll be back with more right after this.